Good day, ladies and gentlemen, and welcome to Chesterton's Jest, where we shine an unflinching light on the joys, contradictions, and crises within today's Catholic Church and culture. If you're here for faith, wit, and a little righteous fire, you're in the right place. Smash that like button, share this video with your fellow troublemakers, and subscribe so you never miss an episode. Now then, shall we begin? Our topic, up for discussion today: Amnesty or Anarchy? The immigration crisis no one wants to name. Chapter 1. The Fence and the Feeling. There is something distinctly modern about wanting the shelter of a house while resenting the walls that hold it up. A nation is not merely an economy or a mood. It is a defined people under a defined law within defined borders. The border is not a sneer, it is a line. And lines exist not because we hate what is outside them, but because we wish to preserve what is inside them. Yet we are told that to enforce immigration law is cruelty, that to detain those who entered unlawfully is heartless, that to remove those who violated statute is oppression. The law, apparently, must now submit to sentiment, but law that bends entirely to feeling ceases to be law at all. Chapter 2. The Moral Inversion. The curious inversion of our time is this: the man who insists on equal application of law is called harsh, while the man who insists that the law be selectively ignored is called compassionate. Equal application of law is not vengeance, it is fairness. It protects the weak and restrains the powerful. It ensures that obedience is not foolishness and that patience is not penalized. If one person waits years to immigrate legally, follows the procedure, pays the fees, and respects the system, while another bypasses the system and is later granted amnesty, what lesson is taught? That law is optional, that scale overrides statute, that numbers create entitlement. This is not mercy. It is inconsistency. Chapter 3. Change the law. Do not evade it. There is a legitimate argument to be made that immigration law should be reformed. One may argue it is outdated, inefficient, too slow, or misaligned with economic realities. That is a political question. But in a constitutional republic, the way to reform law is through legislation. Congress writes the statutes. Congress may amend them. Congress may repeal them. What cannot coherently be demanded is this: that enforcement cease while the law remains intact. To demand that officers ignore statutes passed by elected representatives is not reform. It is selective nullification. If the law is unjust, change it. Until it is changed, it stands. Chapter 4. The Border as Definition. A border is not an act of hostility. It is an act of definition. Without borders, there is no jurisdiction. Without jurisdiction, there is no accountability. Without accountability, there is no self-government. A nation unable to regulate entry cannot define obligation. It cannot determine who is entitled to benefits, protections, or civic participation. Sovereignty is not cruelty, it is coherence. The modern tendency is to treat borders as moral embarrassments. But even the most idealistic internationalist does not remove the doors from his own home. He may welcome guests generously, but he does not abandon the threshold. Hospitality presumes a house. Chapter 5. Compassion without structure. We are urged to see immigration enforcement as cold machinery grinding against human stories. And indeed, there are human stories. Many undocumented individuals are hard-working, decent, embedded in communities. Some have lived here for years. Some have children here. None of that is denied. But compassion without structure becomes chaos. If the presence of sympathetic cases nullifies the law itself, then every law collapses under the weight of exception. The question is not whether immigrants possess dignity. They do. The question is whether dignity eliminates process. If violating a statute results in legalization because the violator has become numerous or sympathetic, then the statute has been dissolved not by repeal, but by exhaustion. Chapter 6. The Citizen and the Compact. The rule of law is sacred in a civic sense. It is the condition that makes ordered liberty possible. A republic rests upon a compact. Laws apply equally, not emotionally, not selectively, equally. When citizens see that enforcement depends upon political mood rather than statute, trust erodes. The citizen who pays taxes, obeys regulations, and follows procedure begins to wonder whether obedience is naive. A government that refuses to enforce its own laws forfeits moral authority. The paradox is that strict enforcement, when conducted lawfully and transparently, produces more trust than selective mercy ever can. Chapter 7. Protest and Disorder. Peaceful protest is a right. Citizens may advocate for expanded visas, streamlined asylum processes, guest worker programs, even broad legalization pathways. That is politics. That is permitted. But obstruction of enforcement operations, vandalism, assault or intimidation are not protest. They are disorder. The rule of law cannot survive if emotional urgency justifies lawlessness. If enforcement officers are prevented from carrying out statutory duties by crowds or chaos, we have shifted from policy debate to civic instability. Disagreement is lawful. Disruption is not. Chapter 8. The Deeper Confusion. At bottom, the crisis is philosophical. Modern culture increasingly treats law as expressive rather than binding. We enforce what aligns with our feelings and suspend what troubles them. But law that functions only when it is convenient ceases to bind anyone. Mercy is a virtue, but mercy presupposes order. One cannot pardon what one refuses to recognize as offense. If we wish to be generous as a nation, let us do so through legislation. If we wish to expand legal pathways, let us vote accordingly. If we wish to offer amnesty, let Congress debate and enact it openly. What we cannot do is pretend that the law does not exist because it discomforts us. Chapter 9. The Stability of Justice. A nation that cannot define its borders cannot define its duties. A nation that cannot enforce its statutes cannot claim to be governed by law. And a people who abandon equal application in favor of selective compassion do not become kinder. They become unstable. The fence exists for a reason. Remove it if you must, but only after understanding its purpose. To tear it down in a fit of feeling is not reform, it is recklessness. The law is not sacred as revelation, but the rule of law is sacred as structure. It is the architecture within which freedom operates. Without it, even compassion collapses. Chapter 10. The Conclusion. The present debate is not about whether immigrants are human. It is about whether a nation may regulate entry without being accused of moral failure. Borders are not sins. Statutes are not bigotry. Enforcement, when lawful, is not injustice. If we desire a more generous system, let us change it through the mechanisms our Constitution provides. But until it is changed, the law stands. And law that stands must be applied, otherwise it is no longer law. Thank you for watching. If you enjoyed today's video and share our passion for defending the true faith with a touch of humor, smash that like button. Share this video with your fellow troublemakers and subscribe so you never miss an episode. As Chesterton once said, a madman is not someone who has lost his reason. A madman is someone who has lost everything except his reason. So, let's keep our reason and our faith intact together. Thanks for listening. God bless you, and may the good Lord be praised.